SJC-13753, Commonwealth versus Kenneth Jose Santana-Rodriguez.
Okay, Hagan.
Good afternoon, and may it please the court. We are asking that you adopt transferred intent self-defense in Massachusetts in one of the following possible two flavors. The first flavor is to adopt transferred intent self-defense as a complete defense. And admittedly, the only jurisdiction that does that, that I can find explicitly, is Pennsylvania. But I think it's worth noting at their reasoning as to why they adopt transferred intent self-defense as a complete defense. And that's because they see the defendant as the victim. I mean, in every case we have a victim, right? We have a innocent bystander who's been killed. That is the victim. But in the first instance, if we find that the defendant was truly defending themselves, the defendant was the first victim. I mean, the defendant was imminently close to death, serious bodily injury, maybe only seconds away from it, when they had to act and they had to make a decision in that moment to possibly try to preserve their life.
How do you compare this to excessive force in self-defense, where a defendant is the victim and we have limits on self-defense and we say that you can possibly, it's up to the jury, find the defendant guilty of voluntary manslaughter?
Sure. Well, I think that question sort of begs for maybe the second flavor in that it is still in that situation where you have excessive force in self-defense, you have a mitigation in terms of it's reckless. It's a voluntary manslaughter. It's a manslaughter that occurs because there's some recognition that you were defending yourself at the time you acted, and so we don't call that person a murderer. We say that that's the frailties of humanity. That somebody in that moment may act and go overboard in their defense, and we're not going to hold them as a murderer. So I think that would really play for, and I don't think that's an unreasonable option, the idea of carving out an exception for recklessness.
Before I cut you off, that was your second prong, right? You would say complete defense or partial defense.
That's correct. That's correct.
And let me just
Sure.
tell, the briefing in this case was excellent. I don't say that lightly, but I just want to congratulate both of you or thank both parties for the briefing in this case.
Appreciate that. Thank you. So, again, just to circle back on the complete defense piece, obviously looking at the defendant as the victim in the first instance, that when they act in that moment, I think the Fallon Court in Pennsylvania said it best when they said maybe all you can do in that moment when your life is imminently threatened is to muster some kind of defense to preserve your life in the split seconds that you have to do so. And so that's why I think you should at least consider the idea.
So if we're not Steelers fans, how about your second option? And help me out. So if it's recklessness in this context, is it voluntary manslaughter that we would be looking, or involuntary manslaughter?
So what I believe is that you should adopt it as involuntary manslaughter. I think it should be a manslaughter if you're going to carve out a recklessness exception. Mm-hmm. What the Commonwealth is sort of pushing is the idea that, well, you see this defendant shot into a crowded room, and when you do that, you know a room is occupied, or you drive by and you shoot into a building that you know is occupied, and when you do that, well, that's third-pronged malice, and so that heightens things to a second-degree murder. I just think that's manifestly unfair to treat those two defendants the same way. I mean, the guy whose life is seconds potentially away from ending acts in a moment of self-defense, even if they're somewhat reckless in their application. Shouldn't there be mitigation, just as you had pointed out in the context of voluntary manslaughter? Because otherwise we would actually set up sort of a very unfair outcome where the guy who acts in imperfect self-defense kills, he's a manslaughter. The guy who, in the first instance, acts in perfect self-defense but is reckless in its application is heightened to become a murderer.
Can I ask you on that second part of it? There are three, as I read the briefs, there are three aspects of the incomplete. One's based upon ordinary negligence. The second is based upon recklessness or negligence. And the third is recklessness. Where do you land on those three subparts? Well, as far as our involuntary manslaughter, if that were an option.
Yeah, so I think if we're talking about involuntary manslaughter in that context, I think that it would be recklessness, but in the flavor of an involuntary manslaughter. So, in other words,
wanton and reckless.
What's that?
Wanton and reckless.
Correct. Yes, which would be a step down from the plain plain and strong likelihood of death of the second-degree murder flavor. I think that's the step down.
It's not third-pronged malice, it's involuntary manslaughter.
That's correct. And I think that's fair because when you look at it, I mean, when the defendant acts in an act of self-defense negates malice as a first principle. So you are not acting with malice at the time you pull the trigger. And so to then impute malice on the back end when you miss, and even if you're somewhat reckless in that prospect, to then impute malice
Doesn't self-defense make it a lawful homicide? Doesn't negate malice?
well, I think if
Because you have transferred malice, right? But self-defense, as I understand it, means it's a lawful, because you certainly intend to kill the person who attacks you.
that's correct.
Right? You have intent to kill when, if you come at me with a knife and
Sure.
you, that's my intent.
Sure.
But it may be lawful.
Yes, it is lawful. There actually is a case, Commonwealth versus Conley, 377 Mass 527. It was decided in 1979. In that case, they said that basically self-defense as a principle negates malice in the first instance. So there is some negation of malice. Now, I agree with you. It is still an intentional act, but I think it takes away, I guess, the idea of the intent to kill when you're acting in self-defense. And so if you start without malice, the ultimate ending should not then impute third-pronged malice back into the equation, is essentially the idea. And I think that's what would be fair, because again,
Is that what Lefebvre in the Model Penal Code do?
that's correct.
So they drop down to involuntary manslaughter.
That's correct. Yes. Lefebvre, other commentators all say it's assault. So if there's recklessness, it's assault and battery if they injure, and involuntary manslaughter if they kill.
And say this, and does the jury draw distinctions, or the instructions draw distinctions between what happens if it's negligence and not recklessness? Does that matter?
Well, I don't know in that context if it would matter. I mean, I think you would need recklessness to get to the involuntary manslaughter. I guess if there's some general negligence, I think that may fall into, because in every instance there's going to be an argument there's some negligence. You missed the person, you didn't hit them.
Right, but
So I think that would, go ahead.
I'm just trying to understand. So I'm just doing all the different permutations you're raising, and it looks like that's at least some of the common law says that even negligence results in an involuntary manslaughter, right?
There is some. I think you get into very tricky waters there, though, because like I said, in every case, if you're going to start talking about negligence, I mean, there is going to be maybe some level of carelessness because you missed ultimately your attacker, you hit somebody else, and I think what we would urge is that this is a complete defense if you simply miss. If there was just or you shot and it went through somebody and hit somebody else or something like that, that would operate as a complete defense. It's only when you add in some heightened mental state. And again, I think that
The facts in following are pretty extreme, because the person's blinded,
yes,
right, by pepper spray, and he's in this Easton, Pennsylvania bar and nightclub. But here, what if you fire at the person and you're 20 yards away and you start spraying, right? That's a different story than what happened in following, right?
So if you're saying if you hear you shot and sprayed, sort of
Yeah, or if you shoot someone who's given the pedicure.
Sure. Well, I think in every instance, remember what protects us is that the jury has to conclude in the first instance that actually you had a right of self-defense and it wasn't excessive, as you pointed out about voluntary manslaughter. So I think that in the first instance, you're always going to have the jury have to look at, well, was the person legitimately defending yourself? And remember, that's in all of these cases. The jury has first decided that you had a legitimate right of self-defense and you were justified in your right in doing so, but ultimately were reckless in its application.
So can I just ask, so you are, you're basically asking us to just make it a broad number of options. So in any particular set of facts, it might be complete or it might be involuntary. I mean, is that your argument?
Sure, that's one of the flavors that I'm saying, which is that if it's simply you simply miss in your application of self-defense, that would still be a complete defense if there's no recklessness involved. Okay, so if I'm legitimately defending myself, but I miss or go through somebody and hit somebody else, then that is a complete defense. I'm entitled to an acquittal, even as to the bystander. But if I'm reckless in that application, one of the flavors that you could consider adopting is to say that is involuntary manslaughter.
But I'm saying it would be up to the jury to.
Up to the jury. That's right. I mean,
Can I ask you, in the briefing, as I read the briefing, a number of states have considered this by statute. We have the common law treatment of it. But there's 0 states where this has been squarely raised, where they've rejected.
That's correct.
Correct.
That's correct. I mean, so there was one state, I think Oregon really, the Commonwealth raises 2. They put Kansas in the mix, but I think Kansas was talking about a pretrial immunity statute, and they specifically say that pretrial immunity, they're not even facing trial, that within their statute that transferred intent self-defense doesn't fit that. However, they explicitly carve out and say, but that does not apply to an affirmative defense at trial context. So while the Commonwealth points out Kansas, I believe Kansas is still in play as not completely defeating the rule. The other case was Oregon, and they do say that their self-defense statute does not contemplate transferred intent. However, in Oregon, I think it's interesting because they group all of their they still consider it a manslaughter. They have essentially a one statute which would take what we call a depraved heart murder, with malice. They consider that still manslaughter. They have a statute that still considers it. So for all intents and purposes, they get to where Lefebvre is. They get to where Commonwealth versus Jackson is out of Michigan, and Morris in New York. So they still get to that same point. I think a corollary to this, though, and the Commonwealth raises it in their brief, and we did it in ours as well, is should somebody in Mr. Rodriguez's position be entitled to a voluntary manslaughter instruction? You have said now for about 20 years, and the Commonwealth says in dicta, although I think it's after 20 years you've sort of been saying that this is a general proposition you agree with, that in a state of provocation, if someone is to go after their provoker and...
That's not reported to us, though, right?
That is not. I just think it's a corollary to this issue as to whether they would be...
It's up to the judge as to whether or not, that's standard fare, as to whether or not voluntary manslaughter is personal, or the provocation is personal.
Sure. Yes, it's just, the reason we raise it is obviously never been firmly established in Massachusetts whether the voluntary manslaughter would, in a situation like that, transfer under these types of circumstances. So would he, is that something, and again, it's to the court, to something...
We don't have to reach that to answer the report.
That's correct. That is correct, yes. I do think, though, that it's important that, you obviously look at this and not give it to the legislature as in the first instance. Obviously, this case is dramatically impacted by it. The Commonwealth cites in their brief that there's at least 2 other cases in the pipeline in Hampden County that needs resolution on this issue. So I think that, and really the legislature in Massachusetts, from my reading of it, has never really been involved in self-defense. I think the only statute that I'm aware of is the Castle Doctrine. So really it's been up to the court to evolve this jurisprudence in this area. And so that's why we ask that you take the time to adopt this and to, in one of the 2 flavors that we request. So if there's no further questions, I'll rest on my brief.
Thank you.
Thank you.
Okay, Attorney Lynch.
Good afternoon. May it please the court, Travis Lynch for the Commonwealth. I wish I had written the brief. It was Mr. Shepard Brick who wrote it, but
Well, I recognize that, but let me
yes,
ask you.
I'll take that.
I'll ask you questions anyway.
Yes.
Are there any states that have rejected this doctrine?
I don't think any, to my knowledge, I don't think any state that has considered it, rejected it, except I think Oregon. But yes, that's my understanding. I mean, there's no unified answer here.
To follow up on that question, have any states adopted the approach that the brief proposes, which is basically that it would drop to second-degree murder?
I'm not exactly sure if that's what the other states have done. I mean, at least on the facts of this case, where the facts are he shoots a gun in the direction that where he knows that a person is.
My understanding is sort of the thrust of the brief is because there's a high likelihood of death, or whatever the standard is in third-pronged malice, that we should really drop this to second-degree murder rather, and I'm just wondering if any other state has done that.
I'm not sure. But our position, I mean, in a circumstance where it truly is accidental, our position is, in some case, it actually does operate as a complete defense. But if the defendant is not careful or not prudent in their act of self-defense, then it's third-pronged malice, at least in a shooting case like this, because of the plain and strong likelihood that death will result. And this position is meant to protect all the innocent bystanders from people like spraying bullets everywhere, or as the dissent in Fallon imagines a hypothetical where the defendant uses a grenade in self-defense and
Before you go there, I'm just making sure I understand. So the Commonwealth is saying that if there's no negligence or recklessness, but there's a dead bystander, it's still complete defense.
Yes. That's, yes. So there is a case, there is a world in which this operates as a complete defense. We're not saying that this is that case, but ultimately it's a jump ball for the jury to decide on proper instructions.
I don't get how that works because it's still transferred intent, right? So the transferred intent is the intent to kill the assailant. It's certainly an intent to kill. That's not third-pronged malice.
Right.
It's intent to kill. And I assume in this case, it's a premeditation case, right?
Yes, that would be our theory of first.
All right.
Yes.
Which is just intent to kill. It doesn't include third-pronged malice. Then how does third-pronged malice come in? If you get the benefit of transferred intent, then you jump to third-pronged malice for the unintended killing? How does that work?
Well, you're acting, I mean, it's justified as the person you're allowed to shoot and kill.
Right.
But if there's other people around when you're...
And you act recklessly in defending yourself, right?
Well, we've said repeatedly, shooting a gun in a direction where you know that there are people is nothing less than third-pronged malice. It's nothing less than plain and strong likelihood of death.
That's apples and oranges because you're excluding the right of self-defense from there. So if you have the right, and as counsel said, to proper, as we say, self-defense, you have a right to defend yourself and to use deadly force to rebut an imminent threat of harm, right?
Right.
If that being the case, it's not like shooting into an occupied building.
Well, if you end up hitting another person and you weren't...
But you're doing an otherwise lawful act. The lawful act is self-defense, as opposed to shooting into a building in a third-pronged malice situation. I just don't think it lines up because you're using transferred intent to prove the deliberate premeditation. So I don't see how third prong lines up to that.
That is, analytically, it doesn't really follow. If the defendant in this case, let's just say, intended to shoot, is it Sanchez, whatever?
Yes, it's Sanchez.
And if he had the right to do that, it's a lawful killing, but now the government gets to switch horses suddenly and say, well, our theory now is this third-pronged malice, and it seems like if you lined it up as an engineer might, it doesn't work. The logic, and maybe that's why you're not sure, and though I'm sure you looked, whether other jurisdictions have adopted the government's theory in its brief, because it just analytically doesn't compute.
Can I ask a different question? You've several times used the word prudent. Is that essentially a negligence standard?
Yes.
Okay, and so can you explain why you think negligence is more appropriate than recklessness?
Well, I mean, I think when we're referring, I'm sorry, it seems like sometimes it's negligence and it seems like other times it's reckless. Yes. But
I don't know.
Is the government arguing? I
Yeah.
guess? Are you suggesting that negligence should be the carve out, or only reckless conduct, like shooting into a building, somehow in self-defense?
Well, negligence. We'll go with negligence.
Negligence is at Walensky, though, in one.
Right, it's not Wolanski, but given that you,
So our involuntary manslaughter law is recklessness, not negligence.
right,
You want this to be different, a different type of involuntary manslaughter?
no, well, if you're not prudent, we want we want this to be third-pronged malice. Because you don't,
So that's reckless, right? Third prong malice.
well, third-pronged malice is like super recklessness.
Super reckless.
Yes.
Chance.
I don't know what else to,
Which is a lot higher than negligence.
yes,
You're relying on I think you're relying on the common law and Lefebvre and the model penal code, which brings in the prudent concept into this mix, right?
yes,
So that it's a lower standard than recklessness, this common law standard, because it's saying that even negligence will result in conviction, right? But that's why I'm struggling with what is it that you're being convicted of involuntary manslaughter, but we're lowering it from recklessness to negligence. Is that what we're doing? I'm just trying to, again, analytically line these up. Because Lefebvre uses the prudent
yes,
standard, right?
right.
Does Lefebvre address whether this distinction between recklessness and negligence? Does Lefebvre sort of comment on that, given, I just don't know.
I'm just looking at in what he's, the quotation in Pina. I apologize, I'm not quite sure.
You know,
about-
you're taking over for Shepherd Brick, we get it, so.
Yes, so I apologize.
See, like, I'm reading from the Model Penal Code, Section 3093. When the actor is justified in using force upon the person of another, but he recklessly or negligently injures or creates a risk of injury to innocent third persons, the justification afforded by those sections unavailable in, I don't know where this goes, but that's the language I believe Justice Wolohojian was focusing on, right?
Yes, I think so.
Do you want to take a shot, though, with Justice Gaziano's question, though? Which is, I don't want to rephrase it, but I just want to make sure I understand your answer to it.
I'm sorry.
Yeah, the question was, our standard of involuntary manslaughter is based upon Commonwealth versus Walensky.
Right.
In cases that follow that, which is more than negligence. It has to be recklessness, wanton and reckless conduct. The Lefebvre and Model Penal Code and some of the statutes involve recklessness and also the option for negligence. The question is, why should we deviate from our involuntary manslaughter jurisprudence and include negligence in this instance?
Because, well, it's to incentivize people when they do act lawfully, when they do act in self-defense, to be careful. That's the whole point of our position.
When we look at the jury instruction for excessive force, right? For example, we say we should assess it with due regard for the frailties of human nature in defending oneself. And I could see a jury instruction in this type of situation, because in Fowlin they said, hey, hindsight's great and you can look at it, but when you're being attacked, you don't have the luxury of hindsight. You're acting instinctively. So shouldn't those same frailties of human nature be involved in this inquiry, as opposed to as it is an excessive force self-defense?
Well, again, the concern is that the person who's killed here didn't do anything. I mean, that's why, I mean,
Right, but you recognize it could also be a complete defense.
yes,
So if someone,
or it's an accident, basically.
right, well, if someone is standing, they're still dead. So if someone is standing behind somebody and a high-powered round goes through the assailant and also kills the person standing behind, you would say that's a complete defense,
Well,
correct?
well,
The person has no liability.
not necessarily, well, it's a high-powered round. That might fall below the standard of care. You don't have to, I mean, or you could throw a grenade at someone and blow them up, you know, and
That might be excessive force.
yes, but so could using an extremely high-powered round that has the chance of penetration. If you use, I don't know, a huge if you use a 44 Magnum and it's you know, it's penetrating through the first person that you're allowed to kill and it kills the person behind
That
you.
would negate the self-defense, right?
Well, it wouldn't negate this. As to the person that you're allowed to use self-defense, I don't think so. It would, as to the person you're not allowed to shoot, the person that you have no justification in shooting because they're not the source of, you know, the threat to you.
But if your bottom line is the person didn't do anything wrong and they're an innocent person, you've also said that it can function as a complete defense.
Right, where it's really accidental.
Can I ask you a hypothetical along those lines? Let's assume the person's entitled as a lawful defense of self-defense. Okay, they're acting in lawful self-defense. And let's assume they're using a gun. They have no training. It's an ordinary gun, not a high-powered firearm of some sort. Ordinary gun, they have no training. They use the gun because they're, you know, in mortal danger. But they miss their intended target because they're unskilled in the use of the firearm. I guess that's what you would call an accident, correct? But in one way, you could see that as a byproduct of negligence, using a deadly weapon that you're not trained to use. So how would we, if we were going to lower this to some kind of negligent, right? Because you could say that it's a standard of prudence requires using deadly weapons, only using deadly weapons that you know how to use. But that would seem to go too far, correct?
I mean, no, I don't think so. I mean, I think that's what
How
our
would you
position-
distinguish that then from the accident hypothetical?
Well, the accident hypothetical is where, I mean, what I'm imagining is like the victim blunders out in front of the person shooting and there's nothing you can do to stop that from happening. I don't think that if you're not skilled with using the firearm, then you're not meeting the standard of care.
No matter what, is there a standard of care embedded in ordinary self-defense? No, it's just reasonableness.
Right. Well, if
There's-
you're not good at using the weapon and you can't aim it properly, then you're not prudently using self-defense. Because of how dangerous these handguns.
If someone's coming at you with a handgun and the jury were to determine that you were entitled to use, you were entitled to self-defense and to use deadly force, we've never had a prudence component embedded into that calculation, have we?
No, I don't. No, that's new.
Okay, so how could you then fit this prudence standard in through this way? In other words, if prudence isn't the standard for lawful self-defense, then why should it be imposed on a situation where there's transferred intent when the person has used lawful self-defense?
Well, it's to protect everyone else. It's to protect all of the innocent. I mean, again, it's different where the person who's hit or killed is not the person who created the necessity. That's why, I mean, that's fundamentally the point of the distinction, I think. I see I'm over time, unless there's any additional questions.
Okay.
Thank you.